All right, it's time for the 6th edition of the No State Project here on, on my Ustream and also on my YouTube channel. Also be at markstevens.net. Glad to do this every Wednesday. And it's December 21st, 2016. Probably it may be the last live show that we do until January, but I'm glad to be here. I got to say, I really appreciate the support of the show. Chris, wow, I really appreciate your support. I can't say how much I appreciate it. It really means a lot. I ask that if anybody else, if they can contribute a bit, that would really help. I know what the problem is. It's not just an issue with my operating system, which I did get to update finally. What a pain in the neck that was. It is my processing speed. Now, I have 2 gigs of processing speed. It's not nearly enough to run the video encoder so that I can broadcast in HD on YouTube. So if anybody wants to get together with some other guys and maybe get me a better processor for a Mac that's higher than the 2, then that would certainly be appreciated. Again, I do appreciate all the support. Ton of stuff to get to. If you want to join me here on the big show, you can do that by calling 218-632-9399, 218-632-9399. Skype, don't call me directly on Skype. Instant message me first, and then we can bring you up. I want to congratulate Dale again. If you go to markstevens.net, I did follow a video and there's an article at markstevens.net, so I did a follow-up video because I didn't think, as I was writing the video, some things that I should have mentioned during the show with Dale, I should have brought up, but I didn't, and so I go through that in the second video. So if anyone is complaining about a lack of content, I don't know, we had with those two videos, 20 minutes apiece. So anyway, there was the last 2 segments of the No State Project live broadcast when Dale was able to call in. That was awesome. And someone's asking me what kind of Mac. I am running a 64-bit Mac Mini. So I've got 16 gigs of RAM on this, but the processor is kind of throttling my speeds, so that is a problem. So I was trying to work things out to do a video with Ginger yesterday and the day before, but the processing speed is just not going to do it. So I actually have a shirt on here just for Ginger. See, can we get that? Yeah, there we go. That's a shout out to Ginger, my Irish brother. So what I mentioned in the video with Dale is, if you remember, Dale testified that the judge at a pretrial conference, was asking the prosecutor if they had read the motion to dismiss and the discovery request, and they had mentioned something that they had skimmed it. He says, I suggest you read it carefully. And the judge asked if they had the evidence that we were asking for, that Dale was asking for, which includes mainly 2 main things. Where is your proof, your evidence, that just because I'm physically in Indiana, that your Constitution applies to me? And then 2 is we want the witness with personal first-hand knowledge of that evidence. The prosecutor lied straight to the judge's face, saying they needed 30 days to do that. Now, what is significant here is if asking for such evidence is frivolous and is not a relevant issue for discovery because no evidence is actually required, then why would the learned judge, Longer, who just got elected to at least his 6th term, why wouldn't he have just said, these issues are not discoverable? This is not discovery because you're not the prosecution can argue without evidence of that. And why, even if the judge missed it, why wouldn't the prosecution just object? Seems objection relevance. That's one of their favorite objections, but they didn't. So that's why I believe this is very significant. So anytime somebody wants to troll and say, no court has ever accepted Mark Stevens' position that evidence is required to prove the Constitution applies, this proves the opposite. Judges are not, especially traffic, where discovery is kind of always a joke. Judges are not in the habit of allowing issues in discovery and ordering a prosecution to provide evidence that's not relevant and it's not discoverable. And then for a seasoned prosecutor to not say, objection, relevance, none of this is discovery material here. I don't have to prove that, and you know it. But there's the kicker there. They didn't. So here we have two Juris Doctorate holders. One very, very experienced, knows his craft. Did not strike those portions from the discovery and Brady request. And yes, having personal knowledge of the matters you're testifying to, Rule 602, does apply in a traffic proceeding. The rules of evidence, it was criminal. So, yeah, if the prosecutor is going to call a police officer, this guy's name was Cody, if he's going to call this guy Cody to testify against him there, he has to have personal knowledge. What's he testifying to? He's testifying he watched Dale violate the code, which means he has to have personal knowledge the code applies. Now, you can say all day long, of course the code applies, of course. That doesn't excuse you from your burden of proof. The prosecution still has to have a witness with personal first-hand knowledge of that, which they don't have because the evidence doesn't exist over here. Yoy. So that, I think, is significant. So if you've got some naysayers, send them over to markstevens.net. Let them see the video. Let them see. I actually posted from the, from the template, the Brady request template. And so let them see that. And also keep in mind, even if pretrial discovery is not allowed, they are still required to provide the Brady material. And the Brady material absolutely does include if the prosecution has an obligation to know if their witnesses are credible and competent. If the prosecution does their job, does their due diligence, and is adhering to due process, they have to know that the police officer, in this example, has no personal first-hand knowledge of the matter he is testifying to. They have to disclose that. My sole witness, it's Brady material. If it's impeachment material is Brady material. It's the same thing, real, okay? It's required under Brady. The prosecutor has to know and has to disclose, to be fair and consistent with due process, my witness does not have personal first-hand knowledge. And if he doesn't have personal first-hand knowledge, then that's it. They're not permitted to testify. But Mark, the testimony, the personal knowledge could consist of the witness's own testimony. What is he going to testify to if there's no evidence? No evidence. Okay. Let's get to the phone calls over here. We have a new caller. We have area code 312. You're live on the No State Project for the 6th episode. What's your name? Where you calling from?
Yo, my name is James Lawrence. I'm calling from Chicago, Illinois.
I'm sorry, I missed your name?
And James Lawrence.
Oh, we just need James. All right. James in Chicago. I hear you you go to Chicago for the pizza, stay 'cause you're dead.
Hold on, wait, hold on. My phone. Let me take my phone off. Now, could you say that for me again?
I said Chicago, go for the pizza, stay 'cause you're dead.
Man, bro, this is jungle out here. Trying to make it out, brother. Yeah, I got in a little jam, right? With I got in a situation where I got a criminal case, and I found out about you, and I wanted to, use this in my situation. But I ordered your the template for the motions to dismiss and the Brady request and all that. But I just got a few questions about filling it out, just making sure that I'm filling it out right, so that I can mail them off.
I'm having a very difficult time making you out. You know what? Could you put your questions into the into Skype, and I can address them there because the audio is just too bad.
Okay.
All right. Yeah. Just put them. Like I said, just put them into the Skype chat, and I'll address that. Okay. All right. I'm sorry about that. No problem. All right. We'll address James in Chicago, his off air. Hopefully, let's see our next caller. Area code 972. You're live on the No State Project. What's your name? Where you calling from?
How you doing? My name's Yao. I'm calling from Dallas, Texas.
Dallas. I'm sorry. What was your name again?
Yao.
Yao?
That's it. It's like Yao Ming, but it's spelled differently.
Oh, Yao. All right, Yao. What can I do for you today?
So I purchased a motion. Maybe it's been a while. It's probably been 4 or 5 years. And my wife and I were on our way to Houston, and we got pulled over by this state trooper. And so, it was a really weird situation. I mean, I guess the details aren't relevant, but anyway, he pulled us over, gave me a speeding ticket. And so I sent the motion to the justice of the peace. And I got a letter back in the mail that said, basically, your motion will be addressed at trial. It said, you need to enter a plea immediately, and the judge will deal with your motion.
So it sounds like the clerk is saying this to you.
Right. The clerk wrote it.
Yeah, it's a very common tactic to try to just run over a motion to dismiss instead of addressing it prior to a plea, which is what's supposed to be done. That's the way things are supposed to work. It's just like if you have a civil proceeding, you don't file an affirmative answer if there are defects in the complaint and it appears that the court may not have jurisdiction. So you file a motion to dismiss, which tolls the time for you to put in an affirmative answer. And it's the same thing here. No plea is required when there's a motion to dismiss pending, because if the motion to dismiss is granted, it moots having an arraignment. I would not enter the plea. And again, they like to do this crap where they say, well, your motion will be addressed at trial. Could you imagine for a second if you were to file against a judge and the assigned judge turned around and told that judge, after he filed a motion to dismiss for lack of evidence, for lack of jurisdiction on grounds of sovereign immunity and absolute judicial immunity. Imagine the judge saying, sorry, dude, you're going to have to file an affirmative answer, and we'll address your motion at trial. Talk about a freaking double standard. There's no way any judge would. A judge would probably walk in packing heat at that point and say, look, we need to square something away here, buddy. You do not force someone to trial when there's a motion to dismiss pending.
Right.
So if I was in that situation, I would not enter the plea. I wouldn't refuse. If anything, I would respond with, hey, I'm more than happy to plead guilty. My intention is to plead guilty if the motion is denied.
Okay, and just you're suggesting to just basically reply to the letter with that information.
Yeah, you can include a copy of the unsigned plea of guilty. So no, if the motion to dismiss is denied, I intend on pleading guilty. And now they're hamstrung. They can't plead not guilty. They may not plead not guilty for you. You've got two reasons why they may not do that. And so if they go ahead and do it anyway, then you'd have to move to strike. I'm hoping you're not too far from Houston, though.
I mean, I'm like 2.5, 3 hours.
Oh, man.
So.
Well, what you can do, too, though, is put in to have a telephonic hearing on the motion.
Okay.
You did send a copy to the police officer, right?
I did not.
Oh, you need to do that, like, today. And this is for you and everybody else listening. Every single thing that you file with the clerk of the court has to go to the prosecutors, or else it's what they call that ex parte communication. Judges and prosecutors seem to do that all the time, and they get away with it because, hey, it's absolute immunity. You and I, we don't get away with it. Plus, it's not a matter of you and I getting away with it. It's just not fair. So get a copy. That's why if you go to the last page of the motion to dismiss is a certificate of service that goes to, and the instructions, it has to go to the police officer and prosecutor if there is one. So because it's just speeding, there may not be a prosecutor assigned yet. So get the address for the trooper at the state police there in Houston and send him a copy as soon as possible. And then what I would do, I would get a motion to have the motion heard. Yeah, you want a motion to hear your motion to dismiss telephonically because you are almost 3 hours away.
Right.
And see what they do. They may tell you to go screw yourself, and you get stuck having to drive almost 3 hours to Houston.
Yeah, I could see that happening, actually. In regards to the motion to have a telephonic hearing, is that basically just, the sort of heading for a motion and then just requesting the court to have the hearing over the phone?
Yeah, and you leave them a phone number, of course. And so, yeah, you can use my template, use the caption, and then just change the title to motion to hear, motion to dismiss telephonically. And just in the body of it say, look, jurisdiction has not been proven. It has. There's no response. Well, you can't. You're going to have to get a copy to the court. I mean, to the police officer. But you can say that there's no evidence on the record to prove jurisdiction. And it's a hardship to expect me, and it's unfair to expect me to go to trial while a motion to dismiss is pending. The motion to dismiss has to be heard first before you can set it for a trial. For heaven's sakes, and obviously you're going to send a copy to the police officer and see what they say.
Right.
If they tell you to go to hell, then you're stuck having to drive to Houston, and because you don't want a warrant for your arrest issued.
Right.
There was actually a judge recently, if you can believe this, y'all, that told somebody saying that if you don't show up, a warrant for your arrest will be issued, was not considered a threat. The judge didn't consider that a threat of violence.
Really?
Yeah. How deluded you have to be when you're telling somebody, if you don't do X, I will do Y, and Y and by that I mean, I will have men with guns take you in here by force. And this individual did not, well, I think he lied, saying it was not a threat. And unfortunately, this individual didn't follow up and say, so if I said to you, if you don't come to my house on this day, I will send men with guns to make sure that you are. Would you consider that a threat?
Absolutely.
So I don't think he's just so deluded and such a true believer that he doesn't really see it as a threat. But he's just saying that because he realized the guy just asked him a really tough question. And for those who are critics who may actually be listening and not just trolling on YouTube, when you tell somebody, get here on this day, and if you don't, men with guns will force you into the building, and they are authorized, so-called, to use deadly force to get you here, that's a threat, no matter how much you believe in the God of government. So the whole point is, don't get a warrant for your arrest and later charge. If you have to go, you're going to have to go.
That makes sense. Yeah. Yeah, I mean, it's not worth it anyway, having to deal with, just looking over your shoulder, basically. Once you get the piece of paper in the mail that says there's a warrant out for your arrest, and knowing that at any time, the police with their automated license plate scanners could figure out who you are, or at least figure out the name your car is registered to and pull you over, because you have a warrant. So
yeah, Yeah. Hey, it's actually 4:20, so in Mountain Standard Time. So, everybody. You know what to do if you're so inclined to do it. Well, hey, I got a line of calls here. Is there any more questions?
Do you think, this last question, do you think I need to also file a Brady request?
Oh, yes. That's why in the instructions, I always show that you always file the motion to dismiss and the Brady request together. So, yes, absolutely.
Okay. I so I can just get that at your website. Is it a regular Brady request, or have you added something specific to, your approach? I say your approach, but you know what I mean.
Yeah, it is. Like I mentioned with Dale, we wanted the main parts of the Brady request are evidence proving the Constitution and Code apply just because you're physically in Texas, and then 2, you want the name of the witness with personal knowledge of that evidence. So email me about that, and I will send you the discovery request.
Okay. Awesome.
All right, hey y'all, I appreciate the call, and I would also encourage you to get into the Skype chat. There's a link on markstevens.net to get you directly to that and start doing some role playing, because you're going to really need to do that. Okay.
Okay, we'll do.
All right,
thanks, Mark.
You're welcome. Y'all in Dallas, Texas, appreciate the call. We're going to have a big day in Texas over here today. We got Jay in Texas.
Is now unmuted.
We have Jay. Hello. Yeah, Jay.
Hey, how you doing, bud?
I'm doing well. How you doing today?
All right. That was pretty funny that I heard 972, and I knew exactly where that was. So it's my neck of the woods. And I'll tell you that I'm going to have to go ahead and say that, and I hope he knows I'm just kidding, but when he listens to this later, but yeah, he was speeding all right, because there's no way you can get from Dallas to Houston in 3 hours. It's not happening unless you're speeding.
Well, he actually said 2.5.
Yeah, and he said on his way to Houston, so it could have been somewhere in between there. So
yeah,
I'll give him that. But I take trips down to Galveston, and that's a 4-hour trip. That's 300 miles all day, every day.
Well, I will say this to everybody. I know that I do a lot of traveling. I'm going back to California. I do that once or twice a month. I've done that for years to see family because, hey, I'm the paraphernalia. And I have had so much trouble with police officers that, to me, it's just, to me, look, if we're going to do it as an activist, that's one thing. But otherwise, if you're not doing it as a form of activism, don't speed. My gosh, it's just... Look, we should be doing everything we can to avoid contact with the police. Even as an activist, we shouldn't be doing the activism with police because it's just too dangerous. And so I may just be a vegan guitar strumming, family man there, but I don't think our activism has to be unnecessarily risky. So keep that in mind, everybody.
Well, hey, listen, with age comes with wisdom. I mean, with age comes wisdom. And as I've grown older, I'm like, am I really in that big of a hurry? I learned to plan a little ahead and go, hey, I'm going to run into traffic. Look, and I don't feel like encounters. So, yeah, I'll do the speed limit 5 miles over, 15% over, and that's it. So, avoid that conflict altogether,
So what do we got going on with you? Do you have some kind of proceeding against you?
I have an update. I'll bring you up to speed again. I have a suspension out of Florida that's over 10 years old. And it carried over into Texas. And, of course, there's no due process or anything. It's just an automatic, you're suspended there, so we're going to suspend you. Right. Just violation after violation of my rights. So they sent me a letter notifying me that because my SR-22 was not showing up on the computer anymore, which I still have insurance. I just don't have the SR-22 because that's just like that permission slip.
How did this is probably important for other people. How did you get the insurance without the SR-22?
I switched insurance companies and I did it online. And they asked me if I needed an SR-22, and I said, you know what, I'm tired of paying that extra money when I don't have to.
and I really didn't know what the outcome would be. I guess I should have probably investigated a little bit more, but I said, no, I don't need it. And so they said, okay, boom, here's your insurance. And, I got my insurance card it's on my phone, and, and off we go. And apparently, shortly thereafter, my old insurance company contacted the state and said, he's not carrying SR-22 with us anymore. We just thought we'd let you know. We're snitches, so there you go. So I do still have insurance, and they don't know anything otherwise. So, it's an active insurance policy.
Well,
that being said, once they found out, they sent me a letter and said, oh, well, we know that you don't have an SR-22 anymore, so we're canceling, we're suspending your occupational license.
Oh.
Yeah. See, because when the suspension carried over from Florida, I was required to go in front of super judge and get an occupational license. And you do that for 2 years, then you have to go back in. Of course, I was going in every 6 months to check in with them, make sure I was doing my law book correctly, blah, blah. So now you can only do that for 2 consecutive terms, so 4 years. All right. So that being said, they got wind, so they said, we're suspending your occupational license. So you've got nothing now. All right. You can't re-register your vehicle, all that, everything that goes along, all the bells and whistles. So they provided me no relief or no remedy. They gave me no information as to how to appeal, where to appeal to. So I sent them a letter saying, hey, I want to appeal this decision, this administrative decision. Well, I just got another letter from them that said, oh, no, you can't. You cannot appeal. There is no hearing for this type of suspension. And as it says, administrative hearings for this type of suspension are not provided by statute. Well, thank you for using the word statute. Because there we have, what statute? And how do you know it applies to me? Correct?
Well, that's true. However, they may be able to submit it to the Office of Administrative Law. So if there's no statutory procedure for that, they may still be able to submit it to the Office of Administrative Law, which I'm finding out only a state agency can do. So that may actually be an option to get that taken care of. So they won't have their own in-house administrative proceeding. But they have to be willing to do that, and we won't know until we try. It ultimately... Sorry?
Go ahead.
It ultimately may come down to you have no choice but to take care of what these scumbags in Florida are demanding, which would suck.
Which I finally I've gotten together the information that I need. I have not sent it off yet because I still need to put together the proper paperwork to send to them. I think we spoke about this, that I could do this telephonically, possibly, to have this thing quashed. File a motion to quash, and do it telephonically. Because again, this thing's over 10 years old. This happened in 06, June of 06.
Wow.
Yeah, and they don't purge their records for every 15 years. Now the county right next to it, they purge their records like every 3 or 4 years.
Well, purging the record doesn't necessarily mean that the suspension is not going to be there, and your connection's getting worse as we go.
All right, is that a little bit better?
We'll see.
Okay. So that being said, I have had discussions with another gentleman who also has a radio show, and I've spoken to him a couple of times about this as well. And he kind of pointed in a direction that really my only remedy on this would be to file a lawsuit against them.
Wow.
Yeah, he's a little extreme, but he deals a lot with the whole transportation code issue. And this guy's an ex-sheriff.
Well, I don't think a lawsuit against the state of Florida, the government there, to unsuspend it will result in what you're looking for.
Well, I'm thinking more in terms of this here in Texas.
Nah, your connection's getting really bad now.
Wow, I'm not even on speakerphone or anything.
Well, that's better now. Whatever you just did is better.
Okay, well, it's uncomfortable. I'm having to hold one leg up. No, I'm kidding. Obviously, this whole thing boils down to money because the next sentence is, well, you need to reinstate your SR-22, and then you need to pay us $100 to reinstate. It's the classic. It's all about money. So they are providing remedy in the sense that if I pay more money to my insurance company and get the SR-22 reinstated and then give them some money, they'll reinstate the occupational license. The problem is it's only going to be good until I think June of next year, and then I cannot even apply for another occupational.
Well, there may be an administrative process available in Florida to help get that resolved. Did you mention it before that you may be able to do something like that and do it telephonically? I mean, usually they can do administrative hearings telephonically, especially since you're not in Florida.
Right. Yeah, much further away than Houston. I like the idea of that option. Of what I need to do is how do I implement that? How do I put that into motion? I've got all the contact information and the case numbers for what's going on in Florida. I've got the clerk's address and everything. So do I file a motion or do I just send them a letter saying that I want to do an administrative hearing?
Well, I would probably start with the motion to vacate the judgment that the DMV is using against you. Because they may actually, I would go the court route first because the DMV may turn around and say there's nothing we can do as long as there's an outstanding court order, that you have to address that and get the court order reversed.
Right.
Now,
because this is all based on an accusation of suspicion of DUI. So it is a criminally, in their terms, it is. I do have a warrant out of Florida, but it's Florida only, and it's been that way since they put it into play. I've been pulled over here and had an officer say, you've got a warrant out of Florida, and I say, yeah, but it's Florida only, and they go, yeah, you're right, and I'm on my way.
Well, that's good. So I guess you'd have to file a motion also to quash the warrant.
Right. That was the last thing that I was told was to file a motion with the clerk, and I would imagine the prosecutor's office file a motion to quash and wait for a response from them.
Yeah, that kind of opens things up again. So you have to see what they'll do.
Okay. Now, with a motion to quash, I don't have to file a Brady motion or anything, do I?
No, you just filed the motion to quash. You'd still want to file a motion. I would still want to file a motion to vacate the judgment. Or there may not be a judgment if it was criminal and you didn't go. There may not be a judgment. There may just be an order, or it may be automatic. Like a lot of places, they will automatically suspend your license if you're charged with a DUI, and so. What they'll do is you'll have to go to a DMV hearing to determine whether they're going to suspend a license or not. So I don't know exactly how they do it in Florida, but So if you don't have a judgment, then just a motion to vacate and motion to dismiss would get it started, and then I would. I lost my train of thought. I hate this.
I'll wait.
No, I'm here on a live broadcast, for heaven's sakes. I completely lost my train of thought, what I was saying. Damn it.
Well, let me just say that in my research, I discovered that the DUI doesn't show up. It shows up, that case now showing up as FTA. And then they show another case that's driving on suspended.
So that's what happened. Okay, so you got
the FTA is based on that DUI.
Yeah, because you didn't show up. So there's no judgment. So to get all right. So you need a motion to dismiss and a motion to vacate, and you need you need a motion to dismiss because you don't need a motion to vacate. You need a motion to dismiss the original complaint, and you need a motion to quash the warrant.
Okay. And then, so I don't need a motion to vacate at this point. I need a motion to dismiss the original citation.
Yeah, they have to actually address. I think since it's been 10 years, I would play it safe and say that they have to address the motion first and the motion to quash. You could always file the discovery request, but we don't know how they're going to respond to the motion. They should respond to at least deny the motion to quash, which we'll see what happens. But you could just play it safe and send a copy of the motion. Of the Brady request. You just have to send it to the police agency that issued the ticket.
Okay, so the sheriff's office there, I would send them a copy or send them a motion for Brady.
Well, it's a Brady request. It's not a motion.
Brady request. Okay.
Since it was criminal, you probably could play it safe. Probably the better thing to do is, since you know the county, send it to the county attorney's office, and and leave the cop out of the loop here. Send it to the county attorney's office and the clerk of the court, and see if they allow it on a telephonic hearing.
Okay.
You're all the way there in Texas. If you're driving with y'all, maybe you can make it to Florida in 3.5, 4 hours.
Well, we'll drive down to Houston and jump on a boat and go to the Tampa Bay area, and because I don't think I would get in trouble in a boat. But then again, who knows? They're everywhere, right?
Yeah, but you may be able to get it telephonically.
What's that now?
I'm just saying, repeating, you may be able to get it telephonically. That would be awesome.
Yeah. Well, when I spoke to the girl on the phone in Florida, which she was extremely helpful and quite cordial. She gave me phone numbers for the judge that's holding in that court now. That's not the one that was there when this happened. So it's a new judge. Even though I never went in front of a judge, so there's nothing, there's no, I remember you kind of thing. She also gave me the number for the state attorney's office. So I think I will call them and get the exact names and addresses. For the state attorney, I will send Brady motion.
Yep.
Brady request.
Yeah, the Brady request.
And then for to the county clerk, for that court, I will ask for a motion to dismiss.
Motion to dismiss. Motion to dismiss. Motion to quash the warrant.
Now, those are two different things, though, right?
Yeah, but they're going to be based on the same. They're going to be based on the same. It's going to be basically the same issues, but you're just going to add a little in there to bring out that there's an actual warrant and that you're in Houston and there's no evidence to support. So all the same arguments to dismiss the complaint are going to be used to dismiss, quash the warrant. It's all based on the same thing. For the warrant to be valid, the court has to have had territorial jurisdiction and personam jurisdiction, and that they can only have that if, of course, the Constitution applies to you just because you're physically in Florida, which there is no evidence of that. So that's why it's all based on that same thing. You just have to call it something different for, just to fit the process. You've got two issues to deal with, which we normally don't have. So,
well, ironically, I small little interesting point here. The DUI that I'm alleged, I wasn't even driving. I wasn't even in the vehicle. I was walking to the vehicle, and a sheriff was at the store that I came out of, and he felt like he needed to interview me, and said, "That's your vehicle?" "Yes, it is." Boom, DUI. I wasn't even driving.
One more reason to stay the hell out of Florida. Because I know in a lot of places like Arizona, for example, if you are in the car physically and you have the keys on you, and they find you just sitting there listening to music, they will still arrest you for DUI. But you're in the car. This guy, prevented you. So he was assuming that you were going to.
Well, what happened was I pulled into that parking lot of the convenience store, and it was too late. I had already pulled up, and he was sitting around the side talking to somebody else, just another civilian.
I got you.
And I went, I said, shit, what do I do? I said, well, I got to do something. So I went to the store, and I stayed in that store for like 15, 20 minutes, hoping he'd just leave. And so when I came back out, he said, can I talk to you for a minute?
Well, yeah, he had an easy arrest. He's going to get off the street for a few hours.
Yeah, even though he had no probable cause whatsoever. His police report said that, I was gripping the steering wheel and staring straight ahead. So, that's a crime. Then he said that there was a beer bottle in the console of my truck. My truck had no console.
Wow.
So, the beer bottle was not taken as evidence. I mean, the case just on itself is so weak, it's ridiculous. But even more importantly is the fact that, he had no jurisdiction in the first place, and that's what I'm running with. So, listen, I'm going to let you get these other calls. Thank you again. I'm going to put this into action, and I'll go back and take a look at this video again and make sure I got all my information right. But, again, thanks a lot, and listen, have a great Christmas holiday, and we'll talk to you next year.
All right, appreciate it. Thanks again, and stay in touch, Jay. Let us know how it goes. Or, yeah, I'm sure he could hear that. We're going to try again with James in Chicago there. James.
Yo, can you hear me?
Yeah, I can hear you. We don't have much time left, though, so it sounds better. So what do we got?
Okay. Yeah, so I just filled out the Brady request and the motion to dismiss. And you answered one of my questions on another call, so I know the answer to that. But I have like a bunch of questions that I wrote down from the other guys, Cop Watch Hawaii. It's like they was practicing role play in the courtroom. And I was just wondering, once I have both of my requests filed, do I actually have to use the scripts, like, questions?
Well, you should be using them. You should be. Everybody needing to prep for court should be using the scripts in the No State Project Skype chat. At least one of them. And you can get that. There's a link directly to it at markstevens.net under upcoming events. You need to be doing that. Even if it's 3 months out, let it become second nature.
Exactly. That's what I thought. That's what I wanted to do. I feel it's best to do. I don't have the script. I got the main questions that they were saying, to practice. And there's another guy named Gary. He put some good tips out there about like the rebuttals, like when they try to get you to force you to comply.
Sure.
Oh yeah, I wrote those down. And I was just curious about that. But I want to tell you about my situation.
Okay, we got to be quick.
Okay, so I got charged with a felony for I don't know if you know about these things. They're called credit profile numbers. So I recently had one of those, and senators and celebrities and judges, all those people, they use those to protect themselves from identity theft, and you also get like an added, the credit boost from it. So, and it's legal. It says on the FBI's website that they're legal. So, I guess I'm not trying to say it's because I'm black or whatever, but I got in trouble for using it because they seen that like I have a little background or whatever. But I gave them back their the vehicle that I had because I went to get a car. I gave them back the vehicle, and as soon as I found out that it was a problem, so I gave them back the car. But the police, they put a case on me, and it's a financial crime. It's like a class 2 felony. And I was just like hoping that like this works, and I believe that it will because just like you said, they don't have the 4 elements of a crime. They have to prove jurisdiction, and
Yes, but that doesn't mean we always get these things tossed out. This is pretty serious. So it was a Class 2 felony. Now, have you been indicted?
Well, yeah, I mean...
Or, are you sure? A grand jury indicted you, or a prosecutor filed a complaint against you?
No, the prosecutor just filed. I haven't got that far. They still, because I had, before I found out about this, I just found out about this, so I got a PD representing me, but she's not trying to work with me or nothing like that. So I found you, and I wanted to use this information.
Oh man. See, these are the calls that suck, everybody. Do you know? I mean, has she entered a plea for you at this point? Has there been a preliminary hearing?
No.
Okay. Has there been a preliminary hearing?
To where they found probable cause to take the court?
Yeah. There was a probable cause hearing?
Yeah, that was the prelim.
Yeah.
The one of the prelim.
You see, this is the opportunity, everybody. This is what kills me. They actually did it, but I'm pretty certain that this lawyer, this public defender, was not challenging the foundation of the prosecution's attack. They were not asking the police officer for evidence proving the Constitution applies just because you're physically in Illinois. I'm pretty certain they didn't do that. I mean, were you there for it?
No, I know for a fact that she didn't do that, because on my last court date, that was the morning that I got the documents from you, and I was studying it, for like a few days before that, and I asked her a question. I said, because she before I even found out about you, I told her that I wanted to just take probation to get it over with, because I'm on electronic monitoring, and I was just wanting to get it over so I can get back in the work, get a job, and help out with some bills around the house. But once I found out about this, I told her I don't want to plead guilty or nothing like that. And she said, it's not getting that far. They still looking at their evidence. The state trying to bring their evidence, to show that it was actually me went to the dealership. But we already know we finna challenge their jurisdiction. But I asked her. I told her, does the Constitution? I said I want to challenge their jurisdiction because you filed a motion for me. And she was like, no. She got real aggressive because that I was asking it, and I was like, well, they got to prove that they got jurisdiction. I said, that's how you did. They got to prove that they got jurisdiction just because I'm physically in the state of Illinois. They got to prove that the Constitution actually applies to me. So she got real aggressive with me, like, it does. Well, I said, can you ask them for the proof? And, she just said, it does. Then she walked back in the courtroom, and she wasn't trying to, she didn't even tell me what she wanted to tell me before she knew that I was going to ask her that. So I had to ask her to come, to come back in the hall for a second again before the judge called my case. And then she told me that they looking to bring the evidence, to court and stuff.
Oh man. So before we're out of time here, as long as you got this public defender assigned and she is representing you and not just standby counsel, you are hamstrung, man. There's nothing. You cannot speak for yourself. You can't ask questions. You can't make objections. You cannot file your own paperwork. So she has to be at least standby for you both to be able to do that. How can I go about doing that? You're going to have to ask her to withdraw as representative and be only standby. It's called standby counsel. So she's there to help. She can, cross-examine witnesses. She can offer arguments for you. She can make objections, and you can also. So this allows you to be able to challenge the things you need to challenge. Because even if someone thinks their client is guilty, you still should be asking for the evidence the prosecution is relying on so you can mount some kind of defense to try to poke a hole in it, to show maybe the evidence maybe the evidence was in violation of the search and seizure clause, the Fourth Amendment. Maybe, it should be excluded. Maybe there's a chain of custody problem. There are a lot of things that just because they make a prima facie case and showing that there's a ton of facts against them, when you start doing a proper pretrial investigation and then you do an effective cross-examination, it could all fall apart. I mean, a great example of that is my cousin Vinny. The woman wasn't wearing her glasses, or the guy was looking through a window that had a lot of dirt on it, and those big things with a lot of leaves on it, trees. So these are very important. So just to throw your hands up and say that the most, an essential element of the crime has been proven just at the prelim? No. There's not, especially when you're looking at a Class 2 felony and looking at doing some time, you have to do what you can to not, look, I have to have all the prosecution's evidence. I need to know everything about their witnesses. Are they competent? Are they credible? And, that's what the Brady material is so important for. Are these competent witnesses? Is it, and look at how it was gotten and be able to challenge that. So she's already throwing her hands up because her job is at stake, her reputation. If she pisses that judge off, you might actually have the case thrown out or have grounds to get it tossed out in a higher court. But so you walk away. You can go and do what you can to escape Chicago. She has to be there every day. So she's going to have to be at least standby so that you can defend yourself. All right, and I added you to the chat. So you should be getting the notifications here soon, because we're almost at a time here.
I got to withdraw her as my counsel, just have her as standby, right?
A standby counsel, yes. Standby counsel. I'll actually write that. I can't.
Right, because I just want to make sure. I want to make sure I'm using the right terminology.
Yes, standby counsel. And that's what you need. And get and start doing the role playing so you can start prepping. Because until that time, until she's only standby, you can write the best motion that the world's ever seen. They have a legal reason not to even consider it.
Okay, dude. Can I my court date isn't until January 5th, so can I call her and request to do that, or does it have to be?
See if she's open to doing it on her own first, and then if not, then you got a real problem. You're going to have to wait until January 5th. If January 5th, I mean, is that a trial or is that a pretrial date?
It's not pretrial or nothing. They just still bringing in evidence because she filed a Brady request, multiple discovery, to see what our evidence the state has today. They just not getting to it because they had a DVD or whatever of me in the dealership or whatever. But that's really all it is. Because at first they had it to where they didn't know what they wanted to charge me, but they tried to charge me with loan fraud, with identity theft. But now they just trying to say it's a false statement charge. So they don't really have nothing on me trying to break the law, because I came in there with all of my information. I applied online, and they approved me, and they told me, come in, get the car. And I signed my paperwork. I was in there 20 minutes, and it was all good. But just, I don't know what they was on, man. I don't know, man. But I brought them their car back, gave them their car, and they flagged the police down and got me locked up. And they seen that I already had a little background. So the police wanted to be thirsty and, put a case on me, and now I'm here.
Yeah, well, the best we can do for right now, see if the attorney will go willingly to, and the judge still has to allow it, but more so, it's much better for you, much better chance for you if the public defender is the one that says, look, I'd like to be standby, so he can has the opportunity to also offer argument and whatnot. So that's what I would do. Let me know what happens with that. And I think you got a quick question here regarding the procedure when filling out the motion to dismiss. Doesn't my address go at? Yes, your address, when you fill out the motion, your address and your mailing address goes at the top left hand on page 1. Do I file the motion and Brady request simultaneously? Yes. But you're going to have to wait until there's standby counsel so you can do that. So keep in touch and let me know what happens with that. All right?
Oh, okay. I'm trying to make sure that's all my questions.
Well, we're pretty much out of time. I want to cover a couple things in the last few minutes. So if you've got any other questions, drop it in. Put it to the guys on the No State Project Skype chat, and if they don't have it, then let me know and I'll respond. Okay.
Okay. Cool.
All right. Appreciate the call. We have James in Chicago, and we got a couple minutes here. I want to welcome good guy. Good guy. Appreciate all the support he's done for the show. He's just now into the No State Project Skype chat. Dan, the man from New Hampshire. Man, he's done some good work. He's right up there with our buddy Bill, who we love so much. The Twin Mountain Country Store up in Carroll County. Oh, there's a White Mountain area. I think it's in northern New Hampshire. So not too far from where they do Pork Fest every year. Hell of a guy, hell of an activist. Dan's right there with him. Very few people in this here world that make principled stands. Bill is definitely one of them. And, of course, Dan, who appreciate the support. Glad to have you aboard there, Paisan. And now we have also James from Chicago in the No State Project Skype chat, which I highly recommend. You've got to do the role playing, and it really helps when everybody in the chat, or most of us in the chat, have already been through this. Not just that we're doing the role playing, but we've actually been to court and we've engaged prosecutors and judges for before, so we could do a pretty good job of anticipating some of the stupid things that they're going to say. I'm going to have another video out real soon. I got a whole board here of videos I got to get to. I want to do the video regarding a judge admitting on an appeal from Marc in New Jersey. Well, I think he's in New York, but the ticket was in New Jersey, where an appellate judge in New Jersey agreeing that jurisdiction is something that has to be proven beyond a reasonable doubt. Although they think it's limited to just proving that you were physically in New Jersey. They want to leave the most important part out, that actually somehow, some way, proves that a written instrument from 200 years ago applies. Somebody connect this for me, because where I'm looking, that's a pretty big non sequitur, and we call that a logical fallacy there, not evidence. So it's not just that you're physically in New Jersey. That's easy to prove, unless you're one of these Freeman sovereign citizen types, but it is easy to prove your physical location, and somebody can have personal first-hand knowledge of that. But personal first-hand knowledge that just because you are physically in New Jersey, that a written instrument applies to you, that's a whole different ball game there. So I'll get that. But Scott in Hawaii is great, because not only do we have Joe in Hawaii, with Watch Hawaii, get 2 serious drug charges tossed out for a lack of evidence. Who would know but Joe? He was there, everybody. But now we've got Scott getting like 5 or 6 charges thrown out, and so this is great. So I'll get that video as soon as I can, and a big congratulations to Scott for taking a principled stand. And that's really one of the things. It's not just that we're getting these things tossed out. It's people are making a principled stand, and they're not just giving in. They're not just going along and go, I gotta pay. It's more people that see these. So even if somebody loses, it is still proving that these people are criminals that we should not be complying with. And that's the main part of this. It's not that, oh yeah, do this, we'll get tickets thrown out. It's we're proving that you can defend yourself against a gang of killers, thieves, and liars. That they are just a criminal organization, a criminal cartel. And we are exposing them for the criminals that they are. So real quick, I'm also going to be doing a video where someone is saying on one of my videos that when I compare the state, which is not physical, it's people, to a church, and that if the church draws boundaries called, let's say, a diocese, like the Catholic Church, that is somehow different than when people called the state draw lines on a map and call that their diocese or their even in Louisiana they use ward. That's religious organizations use that. So they're saying it's a false analogy. They give no explanation as to why that's a false analogy, but everything lines up. You've got a group of men and women who have an organization, a body corporate. Okay? And they're saying that their rules apply in a certain geographic area called a ward or a diocese or a parish. And that, how is that a false analogy? See, what it is it's a critic who has been beaten about the head so many times for logical fallacies that they're trying to project them on me. It's not a false analogy. It's right on point. Which is why they make no effort to show it's a false analogy. But what can you expect? We're at the end of the time here. I do appreciate everyone's support, appreciate the calls. We will not be live this Saturday on LRN.FM. So do not call in. That will be a repeat. We'll probably be replaying this show and some new recorded material. I will be doing a Facebook page. I know I've got to do this. I do have a Twitter that I used to use. I'll reactivate that. If you go to markstevens.net, I do have, and now go to the top. I haven't fixed the whole thing yet. But if you go to the top menu, okay, it will now say newsletter. If you click on that and go, you can now register for the newsletter. That does work now. Don't use the blue icon down near the bottom, if people even scroll down that far. So it's right there at the top in black and white. So even critics, if you want to sign up, even the critics can follow that. Also try, hopefully we can do a video. I'll probably have to do a screen video with Ginger, so we're looking forward to that. And remember, he's at Soulless Productions on YouTube. He's got some great videos there. And remember, we have to do an article about it, but we talked last time about a competition about the best bureaucratic fail, or to get the stupidest thing, the competition to get some of the stupidest comments from a bureaucrat, which is a good idea, I think, because we get more people involved in discrediting these people. Because once enough people with, who understand logic and reason, enough people understand that, then when critics and trolls say, "Oh, we don't need evidence," people will see that as just more proof of how criminal and dishonest status apologists really are. Because what it all comes down to is it's an ethical question. It's an issue of morality. And if you don't allow for a double standard, the people called government are criminals. They are forcing us to pay them on the threat of jail and threat of death. That's a criminal. And only by using a double standard, which is a logical fallacy, can you justify it by saying, oh, it's okay for us, the basic principle of do no harm. That doesn't apply to us because we have these magical documents, magical pieces of paper that are self-enforcing. Self-enforcing. See, if I knew I was going to go on a short rant like that, I would have went and got my certified copy of the Constitution. Just a written instrument. And as far as I know, not magical. Not from the hand of Zeus. So it's a moral issue. It's an ethical issue. It is just wrong to force people to give you money. To force perfect strangers to give you money. It doesn't matter what you do with the money. It doesn't matter if you give them benefits and gifts. You're a damn criminal. And I mentioned on the show before, I have a video about it, that is textbook psychological manipulation. To steal from somebody, to traumatize and terrorize them, and then give them what appears to be a benefit or a gift? Oh, come on. Come on. That's better. That's the Stockholm Syndrome 101. Give me a break. Don't try to, and if anyone ever tries to impose that kind of guilt on you, point it out. You're telling me if I steal from you, but I buy you something nice with the money I stole from you, all of a sudden, I'm not a criminal anymore? Oh, but then we'll go back to first base. Double standard. It's different, they're government. I'll put the challenge out there again for those people who are thick-headed and don't like logic. If you think that those laws apply because a state can pass rules called laws, you have to prove a state exists first. To prove a state exists first, you have to have a body politic and a body corporate, which is comprised of people called citizens. To prove that there are citizens, you have to prove that reciprocal obligations of allegiance and protection actually were created and exist. And you're going to have to do that in light of the hardcore historical and contemporary proof. They're just men and women. That's not up for dispute. And they force us to pay them. Not up for dispute. No rational argument against that. So good luck with that. So if you're going to say that they're different because we have these, it's a state and there's a government, you got to prove that there are citizens and a body corporate and a body politic. Got to do it. If not, you're just, what is it? Vox ex praeterea nihil. It's voice or nothing more. So unless you're going to do this crap about magic, I don't want to hear it. Just give me the proof. We're here live every Wednesday and every Saturday. Present your evidence. No logical fallacies. Just present the damn proof. If you don't have the proof, then just go away. Again, I've got these 2 or 3 that just can't stay off my video. So obviously they're being, anyway, no, I'm not going to give any more time to edit. But I want to thank again for this episode 6, December 21st, 2016 edition of the No State Project. Brought to you by Chris, who I really appreciate the support for the show, and Eyal and Nelson. I do appreciate all the support for the show, guys. If I missed somebody, I do apologize. My name is Marc Stevens. The website, of course, is markstevens.net. And if you've got evidence, I'd love to see it. Until next time,